I hit it. Hello?
Okay, I think we're all here.
Oh, good. Thank you, Judge.
You're welcome. I mean, you're not the only one that has technology challenges, I can assure you. So, Mr. Lifsey, is your name pronounced Lifsey or Lifesey?
Lifsey, Your Honor.
Lifsey, that's what I always thought, but I heard someone earlier today call you Lifesey, and I thought I've never heard him called that way before.
No.
So, Mr. Lifsey, are you going to reserve 5 minutes?
Yes, Your Honor, if I may, please.
All right. So we're ready whenever you are, sir.
Thank you very much. Thank you, Your Honors. Stanford Lifsey on behalf of the appellant Ross Fisher in this cause. Your Honors, we're here before you today on a motion to dismiss with prejudice, which was entered by the lower court. The motion to dismiss with prejudice, we believe, is improper for numerous reasons. Number one, I'm sorry?
No, go ahead, sir. I don't know what that was.
Okay. We believe that it was improper for a number of reasons. The first one being that the motion to dismiss that was filed by Mr. Manny of the second amended complaint did not request dismissal with prejudice. In reaching this opinion that the court did of a dismissal with prejudice, the court stated in essence that it was confusing, or that the complaint was confusing. In the brief, we addressed that issue, that if confusing, it can be handled under a separate rule of procedure, but not necessarily dismissal with prejudice. And
So,
the
Mr.
only
Lifsey,
reason,
I'd like to go back to your point you just made earlier. The
Okay.
fact that there was the request by your opponent was not for a dismissal with prejudice, that somehow takes that out of the realm of the court's ability to grant it. Is that what you're saying?
not out of the court's ability, but the court, to get to that position, would need to fulfill the 3-point criteria, which we stated in the
Okay.
brief.
I just want to make sure that it sounded like your argument was one of preclusion. In other words, it couldn't occur. And
No,
many years as a trial lawyer, a trial judge, and an appellate judge, I've never heard anybody make that argument before. I just want to make sure that I understood it. Okay.
no, Your Honor. I'm sorry. I didn't. It's not my intent to mislead.
Okay.
I mean, in order for the court to do it, it would need to reach the 3-point criteria of, number one, a showing of prejudice, number two, an abuse of the amendments, and number three, that it would be impossible for the plaintiff in this case to ever state a cause of action.
Mr. Lifsey, as I read the record in your argument, you framed the issue as the court couldn't do it with prejudice because the written motion didn't ask for dismissal with prejudice. And then you've thrown in some additional arguments. But at the hearing, when the attorney for the opposing party asked for dismissal, the attorney asked for dismissal with prejudice. In your only response to that, to the trial court, was it wasn't pled. So you didn't argue you should have an opportunity to amend because you could cure the deficiencies in the complaint, or you didn't give any reason why it shouldn't be dismissed with prejudice other than the written motion didn't ask for a dismissal with prejudice.
Well,
So I'm not sure how any of these other arguments are preserved for review.
I would have to ask the court, and I do not recall specifically that Mr. Manny requested the dismissal with prejudice, or that the court, I remember it, I believe I did state, and I would have to go back into the record and look at it, that he did not plead for it. I'm not sure whether or not I went into the 3-point criteria.
I didn't
However,
see it.
however,
I did not
because
see
this
it.
is de
That's
novo
what I wanted to give
review,
you a chance to respond because I didn't see it.
Your Honor, I'm not at liberty right now to go back into the record.
Okay, I understand.
I'll have to accept the court statements. However, under de novo review, the court also looks at it is this proper under any circumstances?
Well,
Not
but
necessarily
but
whether
we
I
review-
preserve the
Sir, I'm
right.
sorry, we review errors that are
Yes.
made by the trial court. And if the trial court didn't reject this, if this argument wasn't made to the trial court, and then the trial court erroneously rejects it, there is no error,
I'm
is what I'm struggling with.
okay.
And a de novo review doesn't mean that we just sort of replow the field, even though it wasn't raised below. I mean, the point Judge Kelly is making is a pretty ironclad point. If you didn't give the trial court a chance to rule on it, we can't correct what they didn't do.
Well, I guess you have to go back behind the purpose of the reason for the dismissal, and the dismissal, if with prejudice, is based upon the fact of the confusion, then that's an improper dismissal. It is not, it should not be dismissed for purposes of a dismissal with prejudice. It would be without prejudice if that is the case, for purposes of I believe it's a 1.140 in the case that I cited, that would allow further proceedings, not necessarily a dismissal with prejudice.
Why don't we shift gears, because there's an issue that I'm dying to talk to you about, because I think we've kind of done all we can do on this
Okay.
one. Basically you got dismissed with prejudice because the trial court said, your challenge to Mr. Manny's fees should have been made in the probate proceeding before another judge whose name I don't remember.
Bauman.
And you didn't make it then. And what you're doing now is you're trying to do a backdoor bite at the apple that you should have made it in the earlier proceeding. Sounds like a pretty good argument to me. It's sort of a res judicata type argument. And I know you've attacked it in all kinds of ways, but it's a pretty darn good argument. I mean, if you were going to raise that issue, you should have raised it in the probate proceeding, not later in another proceeding. I mean, you had your chance and you passed on it.
Okay, first thing, Your Honor, is that it's not for me to raise it. It would be for the client, Mr. Fisher, to raise it. And Mr. Manny wants to point to me as a person to raise the issue. As I stated in the brief, number one, Mr. Manny was still his attorney of record when he filed for the charging lien, which he never perfected, which the court order said that he was entitled to payment based upon a perfected charging lien. That was a lien that he filed, that he sent allegedly to his own client, Ross Fisher, who I now represent, over this contested claim of the attorney's fees that I did not represent. I did not represent him in that case. Mr. Manny represented him in that case. He filed the charging lien against his own client and sent it to the wrong address. So Mr. Fisher was not even aware of the charging lien because it was sent to an address which was over 4 years old, number one. Number two, I don't have any standing even to question the charging lien because I don't represent Mr. Fisher in the probate proceedings. Mr. Manny and his law firm did. How could I step in and challenge on behalf of Mr. Fisher unless he wanted to retain me to challenge the charging lien that he never received?
Mr. Fisher himself did not object in that proceeding.
Mr. Fisher did not object because, number one, he never received the notice of the charging lien. The charging lien was, as noted, is sent to an address, not to
Well,
his
he
address.
may not have got the charging lien, but he knew what the amount of the fee was.
Well, that's an issue too, because Mr. Manny put in the charging lien that it was $30,000. And at the end of the day, he charged it over $48,000. That's number one. Number two, if you're going to have a charging lien, the charging lien, in order to be perfected, has to be ruled upon by that court, which would have been Judge Bauman in the probate proceedings.
Well,
in
again,
order
I'm
for the
not
lien
bothered
to
by
be
this
perfected.
lien process. I am more concerned about that there was a fee that was awarded in the probate proceeding, and it was awarded without any objection from Mr. Fisher or anybody else.
Well, there was no fee. That's the problem. There was no stated amount. Mr. Manny filed a charging lien. The court never found a fee to be paid from the proceeds of what Mr. Fisher was to receive. Mr. Manny, he did his own accounting and said, well, this is what I'm taking and here's what's left over. The court never got to the position of either determining a fee, determining an amount of fee. They only
Mr.
said
Fisher
you're
object-
entitled.
Did
that
Mr.
you-
Fisher, excuse me, did Mr. Fisher object to the accounting?
What, the accounting of Mr. Manny?
Mhm.
After he received what he received, yes, he did. That's
In
why
the
he
probate
retained,
proceeding.
that's why he retained me saying, why would Mr. Manny be entitled to $48,000?
But that's not my question. My question is, did he object in the probate proceeding?
The answer is no. He did he object? There was no amount awarded in the probate proceeding. That's what I'm not sure that I'm being quite clear on this. Mr. Manny filed a charging lien. Mr. Manny never proceeded to have the court determine the charging lien or to determine an amount of the charging lien to make
No,
it a
because
perfected charging
He
lien.
was paid out of the proceeds that Mr. Fisher received from the estate.
Right.
Yeah, so that's how he was paid. He didn't have to proceed under the charging.
Well, it's not, well, Mr. Manny took the money and then paid Mr. Fisher the remaining amount. Mr. Manny never sent an invoice to Mr. Fisher, basically saying, I'm charging you $48,000. He filed a charging
I
lien.
saw a lot of invoices in the record.
Yes, ma'am, you did. And as my client has stated, that in the very beginning, when he retained Mr. Manny's law firm, Mr. Manny's law firm said, don't worry about it. We'll get our money from the probate court. And if they were to
And
get
they
it from the
did. And they
No,
did.
ma'am, they didn't get it from the probate court. They got it from him because the probate court
Through-
never
yeah,
decided how
once
much he
got
was
an
entitled
award Through
to.
the probate court.
Excuse me?
Yes, once he received money through the probate court, once Mr. Fisher
But in order to have,
obtained relief in the probate court.
but in order to have a charging lien, you have to have perfected charging lien or a perfected lien, whichever way you want to go with it. You have to show that you created something that was not already there for the benefit of the client.
client paid the bill.
He didn't pay it. Mr. Manny took the money. He didn't pay it. I mean, I
Okay.
don't know. When you
I
say he
know
paid
that. I
it,
know exactly how it occurred.
that's right. Mr. Manny's firm basically got it into his account, withdrew his funds and paid the rest of it to my client. My client then comes around. He says, why am I paying all this money? Yeah, I object to it. And this is exactly what the court said. This is a fee dispute. And it is a fee dispute because he was never given the opportunity to dispute the fee before it was already paid when the money went into Mr. Manny's account. I mean, I can't be any more clear than that.
Well, he got bills.
He got billed. Yes,
He
he
knew what he
did.
was being
But, well,
charged.
he,
He knew he
Mr.
was
Manny
being
also,
charged late fees for not
Pardon me?
paying them. He's being charged interest, excuse me.
well, he
He's
charged
actually
interest.
getting
He-
bills on two different matters, it looks like.
Well, the problem is that if you're going to file for a charging lien, then you have to comply with the requirements of what a charging lien is. You just can't file it and say, I have a charging lien, and then basically say I'm entitled to whatever money is there. If that's the basis of your payment. There is no contract. We have been provided no discovery from Mr. Manny. We have been roadblocked in every aspect. And Mr. Fisher asked for his file. I've asked for the file. I've asked that it be produced. And Mr. Manny sits there in violation of the Florida bar rules and says, no, I'm not going to give you any part of this file. Now, that in itself slaps in as a violation that would prohibit Mr. Manny from going forward until such time as he complies with the Florida bar and gives the man his file to determine what, if anything additional exists. You just don't sit back and say, well, I'm going to take your money. I'm not going to give you your file, and I'm not going to give you any information. I'm not going to sit for a deposition. I'm not going to provide any discovery. I won't give you your file as required by the Florida bar rules, and I'll sit back and prevail. That is inappropriate. You have, the court answers the question and said they answer it and they say it's confusing. That's why she dismissed it. That is what she ruled. That is the oral pronouncement, that it was confusing. And therefore dismiss it with prejudice. Well, again, if it's confusing, there's a separate rule and separate cases that provide for the remedy under those circumstances. But it's certainly not a dismissal with prejudice. And we ask the court to reverse this matter and send it back to the trial court. And a motion to dismiss doesn't get into the factual circumstances. And that's exactly
Just
what
so you
this
know,
court
you're at
stated
15, but you can
recently
use
in
your
the
time any way you
Bayview
want.
Loan Servicing opinion. Excuse me?
I said you're
I'm
at
sorry.
15 minutes, but you can use your time any way you want. It's your time. But if you wanted to save
That's
5
fine.
for rebuttal, you're into it.
All right. The Bayview case recently decided by this court says you don't get into the factual circumstances. And that's exactly where this court went, is into the factual circumstances of why this case should or should not be there. There was no request for judicial notice. The only thing that it had was a single order, and a single order just said a payment pursuant to a perfected lien. And the only perfected lien was a charging lien. Thank you very much.
Okay. You'll have 4 minutes when we get back.
Thank you, Your Honor.
Mr. Manning?
Thank you, Your Honor. I'm David Manning. I'm representing my firm. One of the things that was entered by is the final judgment entered by Judge Peacock. And I'd like just to publish a brief statement. The court examined the order entered by Judge Bauman in the prior litigation and concluded that any agreement that Lipsey had helped with respect to fees paid to the Manning firm should have been resolved at that time in the order entered by Judge Bauman. Judge Bauman entered an order in which he specifically reserved, he already made a determination as to the nature of the charging lien we had filed. And he recognized the charging lien and he ordered it be paid. The specific point I want to make here is that in response to Judge Leavitt's question, number one, there was no request made by Mr. Lipsey on his behalf or on behalf of his client to file a motion to amend. He did not ask for leave to file another amended complaint. He didn't request the matter at all. Moreover, the record reflects that. Moreover, there was no motion for rehearing addressed to the final judgment, pointing out that the error of the trial judge was in failure to grant him leave to amend his pleading. So that takes care of the procedural point and should dispose of the case. But there's some other points I'd like just to cover ever so briefly. Mr. Lipsey was very actively involved in his own capacity representing himself and his firm in this case almost from the outset. He filed a motion for leave to intervene, and it appears as exhibit number 5 to his 150-page second amended complaint. He filed a motion to leave to intervene in Judge Bauman's court, and he said it was an interest at that time clearly adverse to his present client, Mr. Fisher. The basis of the motion was the ownership of a final judgment he had against Mr. Fisher. And you know what it says in that particular item that he filed. He said in the affidavit in his own motion for leave to intervene that he might be claiming all of the final judgment proceeds that were to be paid in the case. Mr. Lipsey was adverse to the claim of Mr. Fisher from the day that proceeding commenced. And I don't know how he got where he is today, nor do I really care. The judge below made some observations, and I think they were speculative. And I covered that in my brief, in the last portion of my brief, that she did not rely upon what she perceived to be a conflict of interest by Mr. Lipsey in this proceeding, or with perhaps the assignment of a tort claim, which would, of course, be inappropriate. We never got into any of that. We got into it. We resolved the matter immediately with her determination that she examined the exhibits attached to the complaint, specifically the order entered by Judge Bauman, my notice of charging lien, the provision of the order of Judge Bauman, providing that I could go ahead and receive the proceeds of the litigation and then put them in my trust account and pay from my trust account the amount of my fees and then pay over the balance to the client. That is exactly what we did. Now, if there was any objection to that procedure, that objection should have been raised in Judge Bauman's court, in which this attorney, Mr. Lipsey, was a party participant. I mean, he's not a stranger to the proceedings. He has from day one been contending that he was entitled to those proceeds And he's still contending he's entitled to proceed for whatever reason, but he didn't go about it the right way. He didn't file a request to file another amendment. Under the circumstances, the trial judge quite appropriately relied on the exhibits that were attached to his complaint and relied on the order entered by Judge Bauman, made a determination that what she had in front of her was a fee dispute, ruled on that fee dispute, and that was the end of the matter. Now, and may I say, that is the end of my argument, unless you have some questions.
Okay, thank you,
Thank
sir.
you, Judge.
I appreciate it very much. Mr. Lipsey, you got 4 minutes.
Thank you, Your Honor. Your Honor, I've had an opportunity to look at the transcript, and yes, in response to Judge Kelly's question, that is the primary note that I made. I think I was totally taken back, and it's on page 38 of the transcript where it says, I just want to note for the record that there's no request, there's no notice to dismiss with prejudice. That is correct, Your Honor. That is what I stated. However, I was never, before that, Mr. Manny did state that he requested dismissal with prejudice. There's no basis to go forward. And the court stated, I'm dismissing it because I don't see any factual basis. It's internally inconsistent. Now, again, Mr. Manny's doing the same thing, to Your Honors, as what he did in the lower court. He wants to believe that I am there to represent Mr. Fisher in Judge Bauman's court in probate. I'm not there to represent Mr. Fisher. He represents Mr. Fisher, and he has an obligation to him as his client. I don't. Yes, I'm there as a creditor of Mr. Fisher, and I'm not here seeking any fees from me. I've been fully paid by Mr. Fisher for whatever my judgment was that I was seeking to collect in the probate court. I've been fully paid. So let's put that right up front. And I was fully paid right after Mr. Fisher received the funds from Mr. Manny. But
Mr.
what we're
Lipsey,
here
is
for
any of
today-
that in our record, or are you now testifying?
Excuse me? No, it's in the record.
Okay. That you've
It's
been
in the
fully
record.
paid.
Yes, I've been fully paid because he has attacked me and my ethics. And if that's what we're here for, then that's absolutely outside of any pleading and any situation. And that's what he is now bringing before this court, the same thing he brought before Judge Peacock concerning my ethics of the representation. He wants to basically argue and intercede me as the claimant in this case, not Mr. Fisher. I am not the claimant. Mr. Fisher is the claimant who is seeking the recovery of his own fees and of his own money that he never agreed to pay. We asked that the court consider, the circumstances. First of all, it's said in the last 2 pages, if you will, of this transcript, that it's a dismissal with prejudice. I mean, I'm going to say I was probably taken off guard, and I did not put in the other 3 criteria and say, well, you can't do this and you can't do that. But that's, as Judge Kelly points out, I did not do that, and therefore I have to say that. And I'm not going to misrepresent to this court in any way that I said anything different, because that is what I said. But it is Mr. Fisher's rights to contest what that amount of money is that Mr. Manny took from him. And if it is a fee dispute, it is also an independent cause of action that he has. Not necessarily that it has to be decided by Judge Bauman, but it is an independent claim because there was never a decision by Judge Bauman. And if you look to that one single order, it just says Mr. Manny can pay himself pursuant to his perfected claim. Well, what is perfection? And I've already gone over that in the very beginning of my argument. Mr. Fisher would request that this court reverse and remand that this dismissal with prejudice is inappropriate. Thank you.
Thank you both very much. It's well argued, well briefed, and we appreciate your efforts.
Thank you.
Our next case is Philip Morris and RJ Reynolds versus Kevin Dunnigan, personal representative of the estate of Douglas Clarence Dunnigan. I'm sure I haven't pronounced his name correctly.